Approach. Ótimo.
Recording in progress.
Hello? Hi, how are you? I'm okay. Of course. Oh, okay. No, it's fine. All right. All right. Sure. Okay. Thanks. Okay. Good afternoon, Chairperson.
Good afternoon, Mr. Matonze.
Yes, Chairperson is exactly 2 o'clock. If we will start with our meeting.
Can you establish if all members are in attendance? Both
Yeah,
first and select.
Yeah, so far from Home Affairs, I've got yourself, Ms. Mlekwa, Mr. Ross, Ms. Modise, Ms. Lekwase, and Advocate Bongo. There might be others that might have entered the platform. From the
I'm here,
committee.
Honorable Chairperson, Mr. Matonzi.
Oh, okay. Ms. van der Merwe.
Okay, thank you. Dixon?
Good afternoon, Chairperson and members. Chairperson, we have currently 4 members on the platform: Honorable Maleka, Honorable Ndongeni, our Chairperson, Honorable Sheikh, and Honorable Badenhorst. We are still waiting on the other members, but we may proceed. Forgive me, I see Honorable Hadebe is also on, and yes, Chair. If I've forgotten anyone, can you please just let us know?
No, thanks very much. Good afternoon, Select Chairperson, Honorable Shaida Sheikh, and all members of the NA and NCOP, the Parliamentary Legal Services, the Independent Electoral Commission, Chairperson Miebza, and all the commissioners, and the Executive Minister, Home Affairs, and all the team, the Department of Communication, and all the team. And I hope that there's a minister in attendance, the state law advisor, and all colleagues in this important meeting. We've received a brief report on return submissions on Tuesday, and also interacted with the oral submissions that were made to our attention. And all the stakeholders who are invited today were in attendance. Will then are going to receive responses to this meeting. I'm aware that some of the presentations were forwarded late last night, and I'm not sure of the other presentation that I was informed that they were not yet being received. Before we start, I'll request Mr. Matonzi and Mr. Dixon just to update when the report or presentations were received so that we're able to formulate an approach how we're going to deal with all the items. I think that will also influence our decision to process this meeting today. Can I establish, Mr. Matonzi, the presentations and all the stakeholders who are in attendance? Maybe we can then deal with the item number 2, and then we establish who is in attendance. I think that will be informing us on the decision we must take once all the presentation has been made. Mr. Matonzi? Mr. Matonzi?
I'm sorry, Chairperson, I was muted. No, I was saying, no, Chairperson, there are 4 presenters that are supposed to present today on the responses. Number 1 is the Parliament Legal Service. They sent their presentation yesterday, and then it was shared with members yesterday. And then the IEC and the department, they sent their presentation this morning, and then I think they were sent around 9:30. And then I made a follow-up with the Department of Communication. Up to so far, I've not received the presentation, but I think the person that I was communicating with at the department is in the meeting, and then she indicated that not just maybe a few minutes before 2 o'clock that the department will still make a presentation, but I have not yet received that presentation from the Department of Communication, Chairperson. Should I go to the issue of apologies, Chairperson?
And Home Affairs, are they ready?
Yeah, their presentation, I did receive it in the morning, Chairperson. I was saying in the morning today, I received IEC and the Department of Home Affairs. Then the Parliament Legal Service, I received it yesterday. And then the Department of Communication, their presentation is still outstanding, but they are saying no, they will present today.
Okay, I want members to guide on how we must deal with this late presentations, because I'm aware that members could have interacted with the presentations and perhaps consult on other matters. But I want members to guide on how we can deal with it. Or perhaps let me propose that if it will be a proper guidance, I'll start with the select chairperson. But we're going to, I would propose that we'll accept we'll run on the presentations. And we then deal with and I will be guided, Mr. Matonzi and Dixon, on the MOD if we can proceed with that, because obviously we have to proceed with the bill to adopt it. And we give members an opportunity, because we ought to deliberate, and it won't be fair to deliberate outside the presentations that we have not received or they've received late. And I'm fully aware that some of the members have just knocked off from some of the committees today, which I was in attendance with a select chairperson, Honorable Shaida. Then we reconvene on Tuesday. And that will mean, therefore, we must extend time, particularly Home Affairs, because on the deliberations, the select committee won't be joining us. So we'll have to extend time and navigate. I was just want to propose on how we must approach this matter, so that we're fair to both the members, our colleagues who made their presentations in our last on Tuesday, and I'm sure that you already you've also forwarded those presentations to all our colleagues that were giving oral submissions on Tuesday, and also the presentations today. Members, can I get an indication whether this could be a fair framework? Let me start with Mr. Matonzi and Dixon, particularly Mr. Matonzi and Dixon. What will be the implications of us adopting the MOD once the presentation will be made outside without 3.4? in terms of process. Mr. Matonzi, then I will invite members. Right.
Chairperson, the MOD, we only adopt once we want to start with the deliberation on the content of the bill. So in other words, after we have received the presentation, the members must deliberate on whether they want to proceed with the bill based on the submission that we have received on Tuesday and also based on the responses. That's when we adopt the MOD. Then from there, we start with the deliberation on the bill. So as you indicated earlier on, Chairperson, if when we do the MOD, the select committee, they don't have to be there. So that would be the issue of the PC on Home Affairs. So either we do it today on the MOD or we do it next week. If we are continuing with the bill to process it, we have to adopt it, either to adopt it today or whether we adopt it next week or whatever date, Chairperson.
Okay, noted. I'm going to invite select chairperson to comment on the proposal. And then I will check if other members have a different view to the proposal. Select chair. Honorable Shaida Sheikh.
Thank you very much, Chairperson, and greetings to all colleagues, the ministers that are present, and everybody else. Chair, just in terms of your proposal, I want to agree that perhaps in today's meeting, and given that we might have received some of the presentations late, that we actually be taken through the responses by the various departments or the various stakeholders on the public comments. But given the fact that the Department of Communications and Digital Technologies response is not here, perhaps we need to have some time put aside, probably on another day, to get their responses as well. I think in terms of the desirability of the bill, I think that is a matter for your committee. So that the committee can schedule when they need to do that. Thank you, Chair.
Thank you very much. Can I get invite hands on the proposal so that we move faster? Members? Okay. Can I take it that all of us will agree on the process? We'll take presentations. We'll then move to the MOD matter. Then we get a brief from Mr. Matonzi on the program. I know there was issues of also working on a Saturday, so that we take a decision on how we're going to work out our revised program. Mr. Matonzi and Mr. Dection, can I invite the first presentation if there's no any other matter?
Sorry, Chair, my hand was up.
Chairperson, there were hands up.
Oh, okay. Can you
others they lowered their hands, but they were hands up, Chairperson.
Okay. Can you indicate who was unable to?
Mr. Ross and Ms. van der Merwe. There was another hand. It's Alfred Moto. I'm not sure if it's from the Department of Communication.
Okay, let's start with the Department of Communication, then Honorable Ross and Honorable Lizelle. Department of Communication.
Good afternoon, Chair, and thank you for the opportunity. I just wanted to indicate that the input from the Department of Communications and Digital Technologies is not as too substantive to defer to another date. It's just a brief input that. So I request that we maybe take it. Like I'm saying, it's not very substantive to require a separate session. If we could be indulged in that regard.
No, thank you. I'm going to take all the presentations. The matter we're raising is that the other presentation was received late, and members must have an opportunity to go through and also consult and then we'll come back on Tuesday in the meeting. I think it's noted, and thanks very much for that submission. Honorable Ross and Honorable van der Merwe, co-chair. Honorable Ross.
Yes, Chair, thank you. Chair, I just wanted to support that. I think it's, as the department has said, I don't believe those are probably too contentious. They're probably fairly straightforward. But Chair, we're happy to go along with that. But yeah, I'm happy that they present and managed to read the other ones that came in this morning as well. They were not too onerous. So I agree that we take them all and then proceed as you suggest.
Okay, thank you very much, Honorable Ross. Honorable van der Merwe.
No, it's fine, Chairperson. I'm in agreement with Honorable Roos and yourself that we take all the presentations and that we come back on Tuesday. But I just wanted to also flag that remember that the sitting of the National Assembly starts at 10 on Tuesday. So we just need to factor that in because we're sitting from 10 till 6. Thank you, Chair.
Okay, thank you very much. Yeah, we'll see how we navigate with the Mr. Matonsi and Mr. Dection.
Chairperson, before you close, before you move on, you remember on the old program, the one that we were going to be revising, we were supposed to meet tomorrow, Sunday, and Monday. So now I hear you saying Tuesday. So since there's a sitting on Tuesday, if we could maybe meet on Monday, because that meeting on Monday was also approved by the Chief Whip and the House Chair.
Okay. Is that a good program? Let's deal with it when we were on that item. Let's allow the presenters and we'll deal with that and we'll consult with our admin. And I think members understand our pressures, so we'll have to move towards that direction. I'm going to invite the Parliamentary Legal Services and Honorable Lizelle, is the legacy hand or?
Yes, sorry, Chairperson. I'll lower it now. Sorry.
Okay, thank you. Can we move now to, okay. I'm sure all they are in attendance. Home Affairs Minister.
Chairperson, let me check you. You want us to respond about the possibility of us coming on Tuesday?
No.
Yes.
I'm just like whether all of us are in the meeting so that when we move, we're clear.
Yes, we are.
Okay, thank you. Chairperson Muebza.
Good afternoon, Chair, and good afternoon to your co-chair, Minister, and colleagues, everyone on the platform. We are here, Chair, and we will present indeed.
Okay, thank you. We'll take communication that are here and the Parliamentary Legal Service that are here. We'll start with 3.1, 3.2, and if there are comments or questions, then we'll invite the Department of Communications. The last will be Home Affairs. Then we'll.
Chair, I'm sorry. I thought we were still going to take more apologies because we are here, yes, in the first place. But can I leave at 5:30? I have to change my plane very many times to accommodate this meeting, but by 5:30, I'm asking to leave.
Noted.
Thank you.
Done by that time. Parliamentary Legal Services. Can proceed.
Afternoon. Thank you, Chairperson. Afternoon, Chairperson. Afternoon, honourable members, the Minister, and all relevant stakeholders. For those who don't know me, my name is Talana Ali Starkey, and I am the Parliamentary Legal Advisor that has been assigned to this committee to guide the committee regarding the constitutional and legal issues pertaining to the Electoral Matters Amendment Bill B42 of 2023. I just need sharing rights with regards to. Thank you, Eddie. Just give me a moment. I'm sure everybody can see my screen. So as way of background, the Constitutional Legal Services Officers had considered the Electoral Amendment Act of 23, the Electoral Matters Amendment Bill 42 of 2023, the written submissions received by the Portfolio Committee, all oral submissions that took place on the 6th of February, the various legislation that will be amended by the Electoral Matters Bill. And the CLSOs considered the legal and constitutional issues raised in both the oral and written submissions. Chairpersons, there were a number of policy issues raised by submitters in the oral and written submissions, but for the purposes of this presentation, the legal services will only be dealing with the legal and constitutional issues. To the executive to address. In terms of an introduction, and just basically setting out what issues were raised, the public raised the following constitutional interpretation issues on the bill. The general comments to the Electoral Amendment Bill, there were a number of general comments, particularly pertaining to public participation. There were the majority of the submissions were on the Political Party Funding Act, namely Clause 3, the definition of independent representative and independent candidate, and the use of the terms throughout the amendments to the PPFMA, including the omissions of the terms in certain sections. Clause 7 and 29, there were concerns regarding the amendments to the calculations pertaining to the allocation of the funds to the representative political parties and the independent representatives. There was also issues relating to Clause 9 and pertaining to the inequality of the provision. Also Clause 18 regarding the insertion of the new Section 12A. Also Clause 26, and most of the submitters felt that there was an unfettered discretion of the President to determine regulations. And then there were submissions relating to the Electoral Act, Clause 31. There was an objection to the restriction on voters voting for regional seats in a region that they weren't registered. And then Clause 31B, the fact that there was an unequal signature threshold remaining in the Electoral Act. Also, the Electoral Commission Act, there were general comments that certain sections were not amended. The Electronic Broadcasting Act, there were also a general comment that certain sections of the Act are missing amendments, and also that these amendments didn't include independent representatives, and that there should be a definition for independent representatives. And then finally, members, there was a comment regarding the Financial Management of Parliament and Provincial Legislatures Act, relating to the certain sections also being not amended. So to get into it, the general comments relating to public participation was that basically public participation was lacking. The bill was rushed, it was at an unprecedented haste. The period for public comments were extremely short. There was not enough time to allocate it to prepare for submissions, and the inclusion of unnecessary and controversial changes invalidated the public participation or public consultation process and would potentially open the legislation to a legal challenge. Our advice is as follows. Reasonableness is the standard to be applied when whether Parliament has met its obligation. And this we see from Section 59 and 72 of the Constitution. The reasonableness of Parliament's conduct depends on the circumstances and facts at issue from a case-to-case basis. We consider judgments such as Doctors for Life, and this establishes the criteria of how we determine reasonableness and how Parliament has facilitated meaningful public involvement. We consider the rules it has adopted for this purpose. We would then consider the nature and importance of the legislation in question. Without a doubt, this legislation is extremely important in this, and any need for an urgent adoption. We are all aware that time is very pressed. We're very pressed for time. The Constitutional Court in Lamosa's judgment also provides us with further guidance, and there are two aspects that facilitate two aspects dealing with the duty to facilitate public involvement. The first being that the duty to provide that we have done a duty to provide a meaningful opportunity for public participation, and that the duty to take measures to ensure that people have the ability to take advantage of those opportunities have been provided. The committee secretary confirmed the following. The bill was introduced in Parliament on the 8th of December, and after deliberating on the bill and questioning the department on certain issues, the department informed the Portfolio Committee that it was of the view that Parliament proceed with the bill as it was introduced. We then called for adverts, and this was sent out on the 14th of December using social media and the Parliament's website. A second advert then went out on the 11th of January, and the closing date for comments was the 26th of January. On the 29th of January, the committee invited submitters of written submissions to present oral submissions, and then this took place on the 6th of February. Radio adverts also went out during the period of 24th to 26th Jan, and the committee has a considerable amount of pressure. As we are aware, we have pressure to finalize this bill, considering the deadline of the national elections and the importance of this legislation to ensure a well-run election. We are therefore of the view that sufficient time was allowed for inputs into the bill. The first submission that I'm going to be dealing with is clause 3, which is the definitions, and this pertains to the PPFA. So this is dealing with the independent representatives and independent candidates definitions and the use of these terms throughout the bill. The terms independent candidate and independent representative are unevenly applied through the bill. Submitters have said that independent representative and independent candidates are not included in a number of sections of the PPFA. It's not included in the definition of donation or donation in kind, in section 10, in section 14, in section 19.3.4, and in section 23.2. And further, submitters have said that the definition of independent candidate is vague. It is redundant, as it states that an independent candidate is not a member of the party. The definition lacks clarity. It contains words such as intending to contest, and there's no certainty as to what this means. The definition is not synchronized with the Electoral Act. So this is basically what all the summary of what submitters have said about the definitions. We have responded as follows. Regarding the definition of donation and donation in kind, we totally agree with the submitters. The definitions use the term political party in describing what constitutes a donation or a donation in kind. It therefore should include independent candidates and independent representatives. However, the department needs to provide clarity if the policy intention is that a donation in kind or donation would not apply to independent candidates, would not apply to all independent candidates. Members, you'll recall that not all independent candidates may one day be a representative independent candidate. They might not all receive a seat in the NA. So does a donation and a donation in kind apply to all independent candidates, like it applies to all political parties, regardless of their representation in the National Assembly? It's up to the DHA to respond to. The second issue with the definitions would be section 10. And we also agree with submitters. This provision provides that no person may make a donation to a political party or a member of a political party with the expectation that the party or the member concerned will influence the awarding of a tender. It does not include independent candidates or independent representatives, independent candidates with a seat in the National Assembly, independent representatives. There is no legal justification for this exclusion, unless, once again, if the department has a policy intention to not include independent candidates in this provision. If so, it must provide reasons for the exclusion. Furthermore, the department should provide a policy understanding as to why the section was amended, as the current section 10 prevented any person or entity from delivering a donation to a member of a political party other than for political purposes. It now simply includes the proviso in expectation that it will influence an award of a tender, license, or approval. The third issue regarding the use of the terms independent candidates is section 14, and this we disagree with. Only independent candidates and political parties are included in this section. Section 14 relates to the Commission's duty to monitor compliance by political parties with the Act. So it's all political parties, not only political parties with a seat in Parliament. The amendment therefore now includes all independent candidates, regardless of whether they receive a seat in the National Assembly or provincial legislatures. Therefore, there is no need to include independent widely to mean that only an independent candidate only once an independent candidate gains a seat, the provision will then not apply to other independent candidates without a seat. So we once again request that the department provide us with some policy intention, just so that we can gain clarity and perhaps consider a revision to the draft. If we consider section 19.3 and 4, we also agree that this would need amending, because section 19 stipulates offences and penalties. The amendment then introduces a subsection 3, which provides that any person who makes a donation to influence a tender or a license commits an offence and stipulates a fine. It then introduces a subsection 4, which creates an offence for any person who makes a donation to a member of a political party, as opposed to the political party itself. In order to circumvent provisions of Chapter 3, which is Chapter 3 pertains to direct donations to political parties, independent representatives, and independent candidates. So when we considered reading 19.3.4, reading it with Chapter 3, there is no legal justification to exclude independent representatives or independent candidates in subsection 4, as it referenced Chapter 3, and Chapter 3 includes independent representatives and independent candidates. The DHA must provide policy as to why it was excluded, unless this was just a simple omission. And finally, section 23.2, it failed to amend, and therefore independent candidates and independent representatives are excluded. So we also agree with this. We think that section 23 provides that Parliament or provincial legislature may not fund represented political parties other than through section 57.2 and section 1162 of the Constitution. The Constitutional Court in New Nation judgment held that these sections of the Constitution do not negate the possibility of independent candidates participating in the National Assembly and the provincial legislatures, and in turn refer to independent candidates. Therefore, section 23.2 of the PPFA should be amended to include independent representatives. This brings us to the definition of independent representatives and independent candidates. Submitters have said that it was very vague. And we tend to agree, and this is based on simple drafting principles. In terms of drafting prescripts, a definition needs to avoid ambiguity. There are three broad classes of reasons why you would define something. You define it to either delimit it, determine the limits of the significance attached to the term, to extend it, to add the conventional meaning to the term, or to narrow it, to narrow the term and limit the usual meaning of that term. The definition should always assist the reader and not state the obvious. The definition of independent candidate does not align with the definition of the enabling legislation, which is the Electoral Act, that warranted the consequential amendments. If you look at the Electoral Act, it states independent candidate means a South African citizen contesting an election and who is not nominated on a party list. Yet the PPFA says an independent candidate includes any person nominated to contest or intending to contest an election for the National Assembly, provincial legislatures, municipal councils, who is not a member of or is not nominated by a political party. The definition of independent candidate the definition extends the definition contained in the enabling legislation. So it takes the definition from the enabling legislation and extends on it. And this confuses the reader, as it states the obvious. And like I said, a definition should never state the obvious. As Section 31A of the Electoral Act provides for a nomination process, therefore it would appear to be unnecessary to unpack that an independent candidate must be nominated, as the contestation of an election by an independent candidate automatically would require that that independent candidate be nominated in terms of Section 31A. A simple solution would be to act in the definition. Moreover, the definition for independent representative should include the term independent candidate, as to expand and delimit the definition. A simple solution would be to redraft the definition as means an independent candidate who is a member of the National Assembly or provincial legislature. This would therefore curtail the ambiguity and create, means an independent candidate who is not a member, who is a member of the National Assembly or provincial legislature. This would therefore curtail the ambiguity of by who is a member or is nominated by a political party. Clause 7 and 29, amendments to calculations. And we're still dealing with the PPFA. So submitters have said, there's been a call for allocations, this particularly by the ANC, to calculate per seat. There's also was a vast majority of submitters who said that the amendment was a significant shift from the allocation formula and reverted back to the previous formula that was in place prior to the PPFA. The opposition to the formula undermines proportionality. It's not a consequential amendment. Some submitters said that it would be disadvantaged to small parties and independent representatives. It would favor bigger parties and more established political parties who have more seats in parliament. Drafting of the clause 29 was problematic. It was vague. The amendment to item 7 of schedule 2, the upper limits donations, from time to time, people question, what does this mean? It also reverts back to the uneven playing field. It's not a consequential amendment and therefore should not be included. Finally, there were submitters who also said that there was a considerable discussions at the time when Schedule 2 was drafting. And there was a reason behind the decision to move from the previous 90%, 10% to the current 2/3, 1/3. Our legal response is as follows. This is a substantive amendment, as this amendment amends the formula used to allocate funds and is not a simple consequential amendment as a result of the amending the Electoral Amendment Act. The regulations to the now repealed Public Funding of Represented Political Parties Act provided that the allocations would be calculated through a 90%, which is proportional allocation, and a 10% equitable calculation. The previous parliament had its reasons for the changing this provision to 2/3, 1/3. And these reasons were steeped in policy. The amendment now reverts to the original formula and is based on a policy derived from the executive. And it is the prerogative of the executive to develop policy, but it's up to parliament to then interrogate the policy when it is presented in legislation. Therefore, the justification behind this amendment is best left to the department to provide us with understanding and reasoning behind the amendment. However, we would like to caution the committee that this is a substantive change to the PPFA. Independent representatives will always have an unequal footing due to the political nature of the institution. Independent representatives only having one seat and political parties having more than one, so they will always have an unequal footing. But should the change in the formula result in unfairly discriminating independent representatives or smaller parties, the committee must be mindful of the principles set out in Harkson-Liss's name. Does the provision differentiate between people or categories of people? And if so, does the differentiation bear a rational connection to a legitimate government purpose? The rationale behind the legitimate government purpose will have to be left to the department to advise on. Clause 9 deals with the purposes of which money can be used for. The inclusion of a new section 3D seems misplaced. This is what submitters have said. They've also said that it unfairly restricts political parties to cover legal expenses. They've then said that section 2D of the PPFA provides that political parties cannot use monies allocated to defray legal costs relating to eternal political party disputes. But the new edition 7.3D provides that independent representatives and political parties cannot use money allocated to cover any costs relating to any litigation against the
Chair, I'm not sure if I was cut off. I can't hear Telan.
Yeah, Telan? Yeah, I think she was cut off. Mr. Matonsi, can you hear me?
Yes, I can hear you, Chair. But I think it's a network. It's still on the system.
Yeah.
If I perhaps may assist at this point in time, I'm not sure if Ms. Sally Starkey can hear me so that she can forward the slides, then I could, oh no, she's totally off. Mr. Matonsi, if you could give me sharing rights, then I can try, I don't know if I've got her
Okay.
final presentation, but I can.
I have one. It's not that now. I can't remember which slide she was on now.
Yeah, thanks
Are you
for
able to,
the
are you able
inter-
to see this?
I can see that, yes.
Oh, okay.
Okay.
Thanks for that intervention.
It's a pleasure, Chair. Oh, it's jumping. Eddie, are you
Oh,
at the
okay. I'm
right
sorry.
slide?
Okay.
Are you at the right side? Okay. Sorry, Chair, I need to just quickly read so that I also just ascertain where she is and what she is saying. Chair, what we had on that slide that now disappeared, apologies for that. There we go.
Chairperson, so sorry. I don't know
you
what
back,
happened.
Delana?
Why did my internet just... Yes, I'm sorry about that. I don't know why I disconnected.
Okay, please proceed then,
let me
Delana.
just share my... Thank you.
You can proceed, Telana. We've noted your...
Okay, thank you. Sorry. Sure. I'm disabled with my sharing rights, so I just need to...
Delana, Eddie is sharing, so perhaps
I'm
Eddie
sharing.
But Eddie has the incorrect version of the slide, Charmaine. I've updated the slides.
Oh, okay. No, okay. You can share. Okay.
Thanks.
Let me just hold on.
Sure.
All right. You are.
Telana, can I check before you proceed? Just to be clear.
Yes, Chair. Yeah.
If you are saying that you've updated the...
Yeah, there was just one thing that I removed it, and there were a few errors because we had to draft really fast. We only had the submissions on Tuesday, so I picked up a few errors, just grammatical errors.
Oh, okay. No, it's fine. You can proceed, Telana.
And then I altered the last slide dealing with the financial management of Parliament and Provincial Legislatures Act, but I will explain what I altered.
Okay, thanks. You can proceed.
Sure, I'm just going to get to the place where I left off. I do apologize for that, members. The internet can be a tricky thing. So as I was saying, just to circle back, I had explained that if you look at Section 7 and the new subsection 3, it starts off talking about only independent representatives. But then it goes into at paragraph D saying, for the purposes of covering any costs relating to litigation against the political party or independent representative. So the drafting in itself creates some confusion. It appears then that D also now applies to political parties, that they should have any litigation against the political party. Does D refer to litigation against political parties or litigation against independent candidates? If D only relates to independent representatives, then it should be amended to reflect same, because currently that's not the reading of the provision. So we request once again that the department provide us with a political position herein and the intention of this provision. If we move on to clause 18, which is the insertion of a new section 12A, submitters said that the PPFA required all registered political parties to deposit all donations received into bank accounts in the name of the party, and money should not be placed in personal bank accounts. So sections 18A and B does not specify whether the account for independent candidates should be separate from their personal bank account. The issue is that there's nothing to differentiate between monies paid to an independent candidate and their own personal money. A suggestion that came through was that section 12A should be amended to assure that personal accounts of independent candidates are separate from the accounts used for donations. The section ignores the operational and financial requirements of running a campaign as an independent candidate. So our legal response is as follows, that section 12A(1)(b) provides that independent representatives must keep a separate bank account with the bank registered as a bank in terms of the Bank Act, into which all monies allocated to him or her from the funds must be deposited. An interpretation issue could arise as this provision raises the question, separate from what? So a purpose of interpretation would read that the legislature intended for an independent representative to take account of the income, and therefore the reader would logically infer that the reference to separate would be separate account from their personal account. But should the committee wish to have a clearer reading of the provision, we would suggest that we redraft the proposed amendment. Which leads us to clause 26, the unfettered discretion of the president. So there were a number of submitters that said that the president, which is the leader of the party, is in consultation with the portfolio committee, which comprises of members of the political party, decides the level of full disclosure. And this, they believe, is a conflict of interest. Submitters have also argued that the Constitutional Court was clear on democracy and funding as per the My Votes Count judgment. They felt that it infringes upon the right to make informed political decisions, as political parties could reduce disclosure through the president. Similar to they likened the situation to an employee determining their own conditions of their salary. They also suggested that the determination be made by the independent political body, or delete the amendment, or add that the Minister of Finance should be a consultative person as part of the process. They've also suggested that the president should not have such overarching exclusive powers, that it would be vague and it would open to a lot of abuse, and that the president has unfettered discretion. It's far-reaching, and it is a regressive step to accountability. So in our view, this is a substantive amendment to the PPFA. It's not a consequential amendment. In terms of the NUCLEX South Africa judgment, NUCLEX provided that the making of a delegated legislation by members of the executive is an essential part of the public administration. It gives effect to the policies set out by the legislature and provides detailed infrastructure according to which this is to be done. So this sort of justifies what delegated legislation is, why you can make regulations. And then we look at Dawood. Dawood dealt with human rights being affected. And in those instances, clear guidance must be given to the minister who is making regulations. And then we look at Justice Alliance versus President of South Africa. The Constitutional Court held that the legislative powers are delegated in order to ensure that the legislature is not overwhelmed by the need to determine minor regulatory details. Thus, delegation relieves Parliament from dealing with detailed provisions that are often required for the purposes of implementing and regulating laws. So this just sort of gives a justification why there are regulations and why the president or the ministers have the ability to regulate laws. However, the delegate is not intended to travel wider than the object of the legislature. So the delegate's function, in this case the president, is to serve and promote the object of the act, while at all times remain true to the act and the purpose of the act. The court, if we look at Executive Council, Western Cape Legislature versus the President, provided the extent to which legislative powers may be delegated. Namely, that there is a difference between delegating authority to make subordinate legislation within the framework of a statute under the delegation it's made, and assigning plenary legislative powers. Members, you'll recall that Parliament has plenary legislative powers. And so basically the Executive Council case was saying that there's a difference between this, and that this is the difference to having the minister now having the power to amend an act. Therefore, we stress that the committee should be cautioned that in this instance, it could be argued that the president has been assigned plenary power. Prior to the proposed amendment, the president only acted on a resolution of the National Assembly. The reasoning is that the formulation of the regulations contemplated in section 6.2, etc., affects the rights of political parties and now independent candidates, and that such decisions should be left in a multi-party forum, as opposed to the president, the head of the executive. And a resolution process would ensure this. Furthermore, the current draft provides that the drafting of regulations will take place by the president after consultation, which is problematic in itself, as there may be no agreement needed between the parties involved prior to making the regulations. The committee is therefore cautioned that the president could possibly consult with the portfolio committee, not take the advice or recommendations from the portfolio committee, and proceed with the regulations. It is further not recommended that the member of an executive does something in consultation with the legislature, as this would you could reach a stalemate and there would be no ultimate power that can make the final decision one way or the other. So it would equally not be recommended that this be done in consultation. Funding of political parties is fundamental to the promotion of multi-party democracy. It could be argued that to place this power in the hands of the president, who carries many hats, may affect the principles of democracy enshrined by the Constitution, hence rendering the provision unconstitutional. Lastly, minister is not defined in the PFA. Therefore, Section 24(1)A requires a definition as to who will the president consult with prior to making regulations. So there isn't a definition in the Act currently on who is the minister. It is also worth noting that in the current dispensation, the way the Act is read now, the power to determine the allocation resides with the National Assembly, a multi-party forum. The dispensation envisaged by the bill locates this power in the hands of the president, the head of the executive. This is clearly a substantive amendment, the policy for which is not apparent to our office and requires further engagement. Clause 31 of the Electoral Act. So those were we've dealt with all the submissions relating to the Political Party Funding Act. I'm now going to deal with the submissions relating to the Electoral Act, the Electoral Commission Act, the Electronic Broadcasting Act, and the Financial Management of Parliament and Provincial Legislatures Act. So the first submission, the first issue dealing was clause 31. And submitters said, why is a voter not permitted to vote for regional seats and provincial legislatures in another voting district if they aren't on the voters' roll for that province? And there was also questions regarding the drafting of the section and the use of the term or the word or. Now, response is as follows, that the amendment was a suggestion by the IEC, and they are best placed to respond to this technical amendment. But our understanding is that during the policy development meetings, that the allocation of seats per region is determined by the registered population in the region. It follows then that only voters in that region may influence the outcome of an election for that region. However, a greater consideration can be given to the submitters concerned relating the drafting of the section. And once the Legal Services Office consults with the IEC and Oxler, we should perhaps consider a redraft, and this can be incorporated into the A list. So the reasoning behind the lack of amendment to 31B of the Act. So submitters said that 31B of the Act provides the signature requirement should be 15% of the quota, that it was found unconstitutional in terms of the one movement essay judgment. And they question why was the bill has not brought parity to the issue in terms of Section 27CB, which currently provided that in order to contest elections, unrepresented political parties must provide signatures in support of the party totaling 15% of the quota. And as members know, that was overruled by the Constitutional Court. And now, well, not that section, the section dealing with independent candidates. Dependent candidates will only now are required to do 1,000 signatures. Including the reading provided by the Constitutional Court and the issues of disparity between the unrepresented political parties and independent candidates, it was raised during a portfolio committee meeting on the 8th of December. And the executive is vested with the primary responsibility for policy development. Although Parliament has primary constitutional mandate to develop legislation, matters concerning electoral system development is very complex in nature. It's heavily informed by policy consideration. So accordingly, on the 12th of December, the department informed this portfolio committee that it was of the view that the Parliament must proceed with the bill as introduced, and that the department had not yet formulated a position altering the thresholds of unrepresented political parties. Therefore, the portfolio committee did not seek to introduce any amendment to Section 27(2)(c)(b) at this stage. But as everybody is aware, this is currently with the Constitutional Court, and the Constitutional Court was approached to provide clarity on the issue. If we then look at the Electoral Commission Act, submission was that 57(1)(2)(3), 4, 58(1)(2)(3), 7, 59(1)(2)(a), 2(b), and 3 have not been amended to insert independent representative. Was this an oversight on the drafter? And there have been a number of sections containing the Electoral Commission Act that refer to political parties only. And we require the department to provide clarity as to why these sections were not amended. We also noted that there were further sections that required amendment, including section 62B, D, section 9, section 20, and 23 of the Electoral Commission Act. The Electronic Broadcasting Act, the submission was that also section 57, 1, 2, 3, 4, 58, 1, 2, 3, 7, 59, 1, 2A have all been amended to insert independent representative, and was this a oversight? And our response is that we do agree that it needs amending. And now with regards to the FMPPLA, so our legal response is that firstly, the bill neglected to amend 65(1)(f), which speaks to regulations relating to political parties, but there is not an insertion regarding independent candidates, so that needs to be amended. Previously, members, you would have received a slide with me indicating that section 34 may be unconstitutional. We had then looked and consulted broader on the issue. We do not at this stage think that it's unconstitutional, because on looking at section 34 of the Act and looking at section 57 of the Constitution, these are two different funding types. And the real issue is that rules relating to section 34 have not been developed, but are being currently developed. So we have considered it, and I do know that Speaker had raised this in one of her submissions, but we had considered this, we re-looked at it, and we don't find that there's a constitutional issue with section 34. Thank you, members, for your patience. That brings me to the end of my presentation.
Thank you very much, Helena, for your presentation. Can I invite the Independent Electoral Commission, Commissioner Miepza?
Thank you, Chairperson and members. We will make our presentation very briefly. The CEO or his nominee will lead the presentation. Two things appear clear, Chair, from the preceding presentation. We will need to spend some time to align on both sides, it would seem, on some clauses. But secondly, I think it is important to note that the presentation we are going to make follows the submission that was made by Mr. Salmon, Adam Salmon, in terms of the summary that he presented. And I will call upon the CEO to deal with the matter on our behalf. Thank you very much indeed.
Thank you, Commissioner Miepza. CEO Mamabo.
Yes, no, thank you, Chairperson of the Portfolio Committee and members of the Portfolio Committee. We're going to make the presentation in two parts. My colleague, George Mahlangu, is going to deal with the party funding elements, and Mr. Shibori will deal with one or two of the Electoral Act as well as the Electoral Commission Act amendments. And I hand over to George to take us through our comments. Thank you very much.
Thank you. We can proceed.
George, you're muted.
Yeah, thank you very much, and good afternoon, Chair and members of the committee. I'm just loading the screen. Eddie, have you given us the sharing rights?
Yeah, I can see your screen on my side. I don't know if others can see it.
It is visible.
Yeah, it's visible. We can proceed.
Okay. I'm just not seeing it in full from my side, so I'm trying to make it bigger.
Mr. Matuns, can we quickly assist Mr. Mashango?
Yeah, Chairperson, I don't know, but he was just sharing it. So if you can just continue to present.
Yeah, we're loading it now. Eddie, can you load it on your side, please? Thank you very much. Yeah. Chair, we have responded to all the submissions that were presented in the committee. And then this is a detailed presentation of responses. However, some of the responses that are in here, as we go by, you would see that are referring to the previous responses. Basically, what I mean is that where we have responded in detail, in the interest of time, I won't repeat the presentation. The first set of submissions are from my vote counts. Basically, on clause 3, my vote counts are submitting that the donations, the definition of the independent candidates and independent representatives be amended. Chair, we as a commission, we agree with the comprehensive definition of the independent representative and candidates, and that they are necessary for amendment. And we have tried to define the independent candidates and independent representatives. Independent candidates means a South African citizen who has complied with the participation requirements of the Electoral Act to contest an election and who is not nominated on a list of party and accept donations and principally for political purposes. Initially, the definition was not referring to the donations that are accepted by by independent candidates. Secondly, on the independent representatives, we're defining it as a South African citizen who has successfully elected in the National Assembly or the provincial legislature and is not elected on a list of party and accept the donations principally for political purposes. So we try to align this to the definition of a political party as it stands in the current act. Chair, we also agree with the submission that the definition of donations and donations in kind should be amended to include the independents. Next slide. Thank you. Clause 9. Clause 9 refers to the removal of the inclusion of a political party in proposed amendment, which is section 7(3)(d), and creation of a separate subsection. As the commission, we agree with my vote count's recommendation that the word political party is misplaced. Furthermore, we're saying the commission agrees with the submission that the independent representatives may use public funding for legal costs. However, legislation must go further to define what a political party purpose is. So this will help us when an independent go to court to utilize these funds for litigation purposes, so that we know what a political party purpose is. And the legislation must further be expanded to preclude garnishing orders against money from the funds. I mean, we have seen to date, Chair, that political parties are garnished to, that the money that is withheld by the commission must be released in favor of their creditors. So we are afraid that we may see a lot of garnishes coming to the fore when the independents are participating in these legislative houses. Next slide. Okay, we are on clause 18. Clause 18's recommendation is that independents must use separate bank accounts. And we are submitting that the critical question that must be asked here, Chair, for the joint sitting of these committees, is it whether this amendment is consequential or substantive? ANC and COSATU submissions view this as a consequential, and that the two-thirds and one-third allocation formula benefits independent representatives at the expense of political parties. On the other hand, my vote counts and CASAC submissions consider this submission as substantive and should be considered by the next parliament. Our view is that because of the new entrance of the new players in the political space, which are independents, this becomes consequential. However, the committees will have to deliberate on the matter to reach finality. Clause 20. Yeah, clause 20, which is section 14. The exclusion, section 14A of the bill only refers to the independent candidates. It doesn't refer to independent representative. And as the commission, we agree with the submission that section 14A of the bill only refers to the independent candidates and not independent representatives. Therefore, the independent representatives must be included in the provision, and we deem this as consequential. Clause 26, which is next slide. Already I've dealt with on the submission of the ANC and COSATU vis-a-vis the submission of the might vote counts and CASAC. Clause 29. Clause 29 is same as above, Chair. The recommendation is that the reconfiguration of the allocation formula is not consequential, and the amendment therefore should not be included in the bill. So that is the question that we're asking to the two committees, that is this a consequential or a substantive amendment? Clause section 23, which is page 6. Right. This section, which was not commented to in the submission, but the comment is not in the bill, but the comment was taken directly from the Act. It relates to the funding of represented political parties by legislatures. Now, the bill, I mean, as it stands, the Act doesn't consider independent candidates to be allocated funds from the legislatures. Section 23 of this Act provides for funding of represented political parties by legislatures. And now that independent representatives will be part of the legislatures, this section becomes consequential. And the committees to deliberate and conclude on how the independent representatives be provided for under this section of the bill. The next one, which is the Electoral Act, my vote counts submits that the matter of the signatures of the 15% and the 100 signatures has not been attended to. And our submission is that this matter is before the Constitutional Court, and the commission has filed a notice to abide. So this matter, what is critical, Chair, is that this matter is extremely time sensitive. And if it is not, attended before the proclamation as attended, it may create, unnecessary problems. The next clause, which is clause 3, from advancement of South African Constitution, which is CASAC. CASAC is making a submission that there is no need for the bill to change the definition of the multi-party democracy fund. And the Commission agrees that the multi-party democracy fund name change is not necessary. And in the New Nation movement, the Constitutional Court held that the word multi-party does not exclude independence. So we agree with CASAC. And the same on definitions is still applicable on the multi-party democracy fund. So we are of the opinion that there is no need for the multi-party democracy fund definition to be amended. Clause 9. Clause 9 refers to the submission by CASAC that they submit that the inclusion of political parties in section 7 3D is inappropriate and should be removed. This has been dealt with, Chair, on my vote count submission, which is on page 3. So I'm not going to repeat what has been submitted through my vote count. Clause 19 refers to unspent money at the end of the financial year. So what CASAC is submitting here is that the amendment is impractical in respect of political parties. So basically this refers to when an independent candidate ceases to become an independent candidate, what happens to the funds that would have been allocated to the independent candidate? So the Commission submits that the clause is consequential to IRs, and therefore we agree with the submission that the new section of 13.3 of the Political Party Funding Act should apply to IRs and not to political parties. Clause 20. Clause 20 also refers to the exclusion of the independent representative from section 14. And Chair, we have noticed that the word, independent candidate and independent representatives are used interchangeably in the bill, even though they mean different things. So the Commission agrees with the input that the independent representatives should be included in the provision of the clause. Clause 24. Clause 24 refers to section 19, which deals with offenses and penalties. The Commission, CASAC is submitting that the Commission be given additional powers to monitor political parties' bank accounts and sharing such information of non-compliance with NPA and FIC. Chair, we consider this as substantive, rather consequential. However, if there's a view that the Commission's investigative powers must be strengthened, we are leaving this, to the committee or the new parliament to consider this submission. Clause 26, which refers to section 24. This is the submission of President's powers to stipulate thresholds. And our submission in this section 24 regulation, Chair, is that this provision is arguably not consequential but substantive. The Commission is of the view that the current provision, which is in the Act, must be retained as the involvement of the legislative arm in the process does ensure that there is a multi-party participation in the eventual determination of the limits and the threshold. So we're saying the National Assembly should be the one that deals with matters of this nature. Clause 29, which deals with section Schedule 2 of the regulations, is the same as the above because it relates to the funding, the current allocation of funding to the political parties and independent representatives in these two legislative houses. The second part of section 29 of clause 29 relating to schedule 2 is linked to the threshold, and we also saying the Commission is of the view that the current provision must be retained as the involvement of the legislative arm in the process does ensure that the multi-party participation is eventual determination. The submission from Michael Atkins, Chair, this has been dealt with in the clauses 14 and 24 of the My Vote Counts. Basically, it relates to the separate bank accounts that must be kept by the independent representative and independent candidate. So we agree with the recommendation that the separate bank accounts be agreed upon. Clause 18, which is section 12, to political party funding, to political party account, and the political parties accounting for income. The commission is of the view that this is consequential, and there's a need for independent candidates to declare their intention as soon as they have decided that they want to contest. So once this is known to the commission, then they will fall under the ambit in terms of making sure that they comply with the law. But for the ensuing 2024 elections, the independent candidates will be required to make declarations upon certification as the independent candidates, because we can't retrospectively apply the law. But in future elections, I think once their intentions are brought to the attention of the commission, then within that period, before the elections and that period, then the law kicks in. Clause 19 refers to the reference of represented political parties that must be removed from section 13. And we submit that the clause is consequential and independent representatives are therefore, we agree that the submission of the new section 13.3 of the of the Political Party Funding Act should apply to IR and not to political parties. Clause 18, this is just a tautology, Chair, and we agree to that. Clause 20, this was dealt with in my vote count submission, which was clause 20, which is on page 5 of 34. So I'm not going to repeat that. And then the next section is the section 23, funding of represented political parties. Section 23 was dealt with in my vote count submission. So, Chair, I'm not going to repeat this section. And then similarly applies to section 23, funding of represented political parties, where the recommendation is that independent representative must be funded by the legislatures, which we agree that that section has to be looked at to include independent representatives. Clause 26 and 29 refers to the president's powers, which somewhere it was called unfettered powers. So it has been dealt with in the CASAC submission that the status quo must be kept, Chair. Section 26, same applies with that the powers that are given to the president. We are of the opinion that the current status quo must be retained. Section clause 29, which refers to Schedule 2 of the regulations on political party funding. This was dealt with in my vote count submissions. That's where the ANC and the COSATU and COSATU are looking at this amendment as consequential. However, the my vote counts and CASAC consider this as substantive, and we are of the view that it is a consequential amendment. However, we are saying the committee would be at liberty to deliberate on this matter. Clause 29, I think it's an inclusion of the independent representatives, and we agreed with that. The submissions of Dr. Albertus Skuman. Dr. Albertus Skuman refers to the thresholds, and we have dealt with the thresholds, Chair, in the previous submission, so I'm not going to dwell much on it. Clauses 20 and 24, it was also dealt with because we have noticed that all the submissions appear to be in favor of the separate bank accounts for independence. However, the determination of whether the second bank account must be in the name of a vehicle or in the personal name, I think the committee would be at liberty to determine whether the independent must open a personal bank account or must register an entity that will be responsible for the affairs of its political activity. And then in the same vein, there's a recommendation that political parties and candidates could be required to publish the number of donors. So this submission suggests that donations under the threshold must also be disclosed. The Commission is of the view that this is a substantive submission and should therefore be deliberated on by the new Parliament. Clause 14, this is intra-party elections. This relates to the funding and of those who will be contesting for intra-party leadership contestations. And as the Commission were of the view that this is substantive and therefore should be deliberated on by the new Parliament. The next issue, which is clause 4, under this, the doctor is referring to the public funding of political parties, and what is suggesting that a development of the new policy framework on public funding has to be looked at. And we are viewing this as a substantive submission and therefore should be looked and deliberated at by the new Parliament. And then the next submissions are COSATU submissions. And we have dealt with the COSATU submission. Somewhere the COSATU, they are looking at the thresholds, and we are of the opinion that this is a substantive amendment because the might vote counts and the KESEC are looking at it differently from what COSATU and the ANC is looking at. And then the last submission of COSATU refers to the removal of provision relating to the disclosure of donation below threshold. And our view is that this is a substantive submission and should therefore be deliberated on by the committee or the new Parliament. Clause 38 refers to the Electronic Communications Act. Chair, we're of the view that ICASA would be best placed to deal with this submission. The next submissions are submissions from Zaki Ahmad, where he submits that there must be a distinction between either the natural person, the vehicle of the natural person or a juristic person should be used for the purposes of independence. And as the committee, as the commission, we note the submission of the establishment of the vehicle or an entity and support and facilitate the campaign program of the independence. And we view this as a consequential amendment, and the decision is left to the committee to determine whether which vehicle the independent must utilize. And we furthermore submit that the bill should be amended to include the clause that provides for the registration of intention by the aspirant independent candidate. Clause 3 has been dealt with in the My Vote Counts submission, so I'm not going to dwell on it. Clause 3 on Section 1 definitions, it has also been dealt with under the Clause 3 in My Vote Counts submission. The next submissions, Chair, last but one, are submissions from the People's Legal Center. They are also arguing on the natural or juristic person as a way of vehicle that will be utilized by the independent candidates and representatives. And our view is that this is consequential, and the determination of the nature and entity of the vehicle, I think, will be left for the committee to determine about it or on it. The second recommendation that is made by the People's Legal Center, revolves around they submit that there should be a process for independence akin on the registration process, that when their intention is known, then the law should apply. So we submit that the bill should be amended to include a clause that provides for the registration of the intention of aspirant independent candidates at the time when their intention is known. And then the second submission from the NGO is on the prohibited donation, that the training should be extended to the independent support staff. As things stands, the training and development donation from the foreign source can be received by a political party, but the political party is expected to train its members. Now the independents, as they are coming as an office or as one, the submission is that the training must be extended to the staff members or the support staff of the independent candidates, independent representatives office. And we are of the view that this is consequential, and we submit that this must be extended to the independent representatives. Clause 17 refers to the intention to contest, which I've dealt with. We submit that once that the intention is known, this should apply to independents. And then the fourth submission from the NGO refers to intra-party campaigns. I've dealt with it. As the Commission, we submit that the question of intra-party fund and campaigns is a substantive matter. Therefore, the committee be allowed to deliberate to finalize on it. Submission number 5, it was dealt with in the Kazakh submission, which was on clause 26, which is found on page 10 of 34. So we are not going to dwell much on it. Submission 7, these are various oversights, Chair, which we support. The first one was that the independent representative can't use the money that it receives from the funds to procure immovable property. So we are of the opinion that it is a bit unfair for IRs not to equally use that money to procure immovable property as it applies to political parties. And we further agree that the IRs should be allowed to use funds for litigation in favor or against the third parties for political party related activities. And that, this must be defined so that we know exactly what kind of an animal we deal with. This was also an oversight on clause 19. The submission, Chair, refers to 13.3c, but in the bill, there is no 13.3c. So we're not sure where the NGO, got 13.3c. Clause 20, it's another oversight that refers to inclusion of independent candidates or independent representatives, and we submit, Chair, on both clause 20 and clause 20 to 24. Lastly, the African National Congress submission, Chair, again here we're saying this is a critical question that must be considered by the committees, whether this amendment is consequential or substantive, because there are two different school of thoughts here. And I think once that question has been answered, then we'll be in a position to determine whether this goes into the new act or not. There's additional note, Chair, that we are putting here. The definition of the independent candidates in the bill is extended to include municipal councils. This may have unintended consequences. For an example, a ratepayers association which is at municipal level is registered with the commission, and once it is registered, it falls within the compliance ambit of Political Party Funding Act. But a municipal councillor who's represented at the same local level, who is an independent representative, is not expected to comply with this act. So we're saying the inclusion of this definition of municipal councils at this level may create problems on how do we deal with political parties that are only represented at local level vis-a-vis their counterparts who are municipal councils, who are municipal councillors at the same level. Chair, I will hand over to my colleague, DCO Shiburi, to look at that one page of Electoral Act 73 of 1998. Thank you very much.
Thank you very much, Mr. Mahlangu. Mr. Shiburi.
Thank you, Chair. Mr. Matons, can you scroll down? Again. Thank you very much. Chair, I'm going to deal with one pointed aspect. It is in clause 31 of the bill. The comment there was that what is the justification for not affording voters who vote outside of their voting station by way of Section 24? Why are you not according them all the ballots? Two, there is a possibility that in its current form, the bill may be interpreted in more than one way. So we are proposing a redraft, which we have shared with parliamentary legal to look at so that we can propose to the committees for inclusion in the bill. And that reformulation is to clause 31 of section 34A, starting with the words, provided that such voter may only vote in the election for the regional seats in the National Assembly in terms of section 1A, we propose that we remove or and replace it with and for the provincial legislature. That specified voting district is situated in a province within which the voter is registered. So it seems to it intends to do two things. One, remove confusion that a voter may be entitled to one or the other ballot, and to make it clear that a person who votes by Section 24A outside the province in which they are registered is only entitled to the national ballot. They forfeit the regional as well as the provincial legislature ballot. The second comment, Chair, it has nothing to do with the law and drafting. We're just offering a response for purposes of completeness, is that Section 24A has already been amended. And the critical element of the amendment is as follows. One, hitherto, Section 24A was available by application at a voting station. It has now been clarified that Section 24A is only available by pre-notification to the Chief Electoral Officer in a period within the timetable. And because only persons who would have notified the Chief Electoral Officer in a period within the timetable, we will know upfront who's going to vote by Section 24A and at which other voting district they will cast their ballot. So there won't be a need to make provision for additional ballot papers across all 23,000 voting stations. So we think the risk that is identified by the submission has been adequately ameliorated by the amendment to the section. That concludes our input, Chair. Thank you.
Okay, thanks very much, Mr. Shiburi. I would suggest that we take Department of. Let me go back to Commissioner Muyabza. I think that all the presentation or responses.
Yes, Chairperson, thank you very much for the opportunity. That represents our input into the responses we had to give back to yourselves. I do raise the issue, and it can be dealt with under the discussion. There are points at which our input and that which has been made before us have differences, and I am submitting to you, Chair, that the committees must determine at what point we need to deal with, and whether we need to consult each other offline and other things. It's a matter that we can consider later, but these are our inputs at the moment.
Okay, it's being noted. We'll then deal with that after the presentations. Let me invite the Department of Communication and Home Affairs, then so that we're able to deal with all the presentation, particularly on our earlier decisions that will not deliberate and will reconvene on Monday. Department of Communication.
Thank you, Chair. Dr. Harabian will present on our input as it relates to the Electronic Communications Act. Thank you.
Thank you, Doctor. You can proceed. Yeah, can you proceed, Doctor? Because unless you're Mr. Matonzi.
Okay.
Mr. Matonzi?
Yes, Chair.
Oh, I thought it's on my side.
No, it's not on your side, it's from their
Okay.
side.
All right. Can we try to locate them, Mr. Matonzi? Mr. Matonzi?
Chair, I'm trying to
Good
call.
afternoon, Chairperson.
Yes. Afternoon. How are you?
All right, Chairperson, and good afternoon together to members. Chairperson, I'm Sekhupa Harabiai, Acting Chief Director, Legal Services. I'll be presenting on behalf of the department this presentation, Chairperson. If I may proceed.
Thank you. You can proceed.
Okay. Thank you very much, Chairperson, and to members. Yeah, maybe as a remark in passing, I should indicate, Chairperson, that our comments here are only relating to ECA, Electronic Communications Act. So what I must also mention, Chairperson, is that there's only consequential amendment. The only consequential amendment which are made in line with the court judgment is that where the act was saying, for instance, political party, we have included the word independent candidate or independent representative. So to make provision as and when there is a broadcasting. I just wanted to highlight that. So as a background, like I said, it makes consequential amendments and so forth. The ECA was only dealing with political parties. As I mentioned, it must now be amended to allow for the introduction of independent candidate and independent representative in line with the judgment by the Constitutional Court. And in terms of the amendment actually affect section 56 to 59. So we amended the definition of this election period, the definition for a party election broadcast, and also for political advertisement, also so as to make a provision for the independent parties. And slide number 4. Yeah, Section 56 is the one that is affected. As I mentioned, there's also definitions that are affected. Section 56 deals with provision on broadcasting of party election and political advertisement. So we included the word independent representative and independent party. There's also Section 57 that we did the same, included the word independent candidate, Section 58, and also Section 59. So after thorough consideration from the department, we noted that the bill intends to amend this act to make, and I must emphasize, the consequential amendment resulting from the introduction of independent candidate to contest the election of the National Assembly and provincial legislation. So to us, the department, there are no major changes insofar as, or to the extent in which the ECA is concerned. And slide number 5, as I mentioned and emphasized earlier, Chairperson, it concerns consequential management, which amendments which impact on ECA to the extent of including independent candidate and independent representative in line with the court judgment. For instance, as I highlighted, where ECA refers to political party, the word independent candidate is added to ensure alignment with. So from our side, this amendment, insofar as the ECA is concerned to the department, they are not substantial. They do not alter any intended purpose in which those provisions that I mentioned, they do not alter the purpose in which the legislator intended to achieve in those provisions that I mentioned, meaning 56, 57, 58, 59. They do not alter any purpose or what, but just merely to add the word independent representative and independent party. I think, and as from the department, we support those amendments. I think that's all I can say. Chairperson, and let's see if there's anything that I should perhaps clarify. So thank you very much, Chairperson and honorable members. Thanks very much.
Okay, thank you very much to the Department of Communications and Digital Technologies. On members, as the Chairperson Chabani had said earlier, that we'll then take the presentation from the Department of Home Affairs as well. I'm going to call upon the Minister to open the session for that. Honorable Minister. Minister, are you still on the platform?
Yes, thank you very much. Yes, I'm here. Thank you very much, colleagues. Colleagues, we had a little bit of a problem in Home Affairs. You are aware that right from the beginning, our bill, the bill that we passed in Parliament was drafted by a private company, not the department. We told you that we hired something private because it was too complex for the department officials who were there at that time. And it was given to Advocate Senior Counsel Steve Bartlender, who, as you know, has since left the profession. When the matter was taken to court, he had to ask for permission from the Legal Services Council to allow him to appear in court to defend what he has put in front of Parliament. He has done so. You know, the judgment has been made. And from there, he left us. And he gave us his junior counsel. Now, during the public oral hearings, all the recordings and everything was given to that council to put a response for us and give it to us so that we discuss it with him and present it here. But we also thought, because these are technical things emanating from the law, he will also be here to explain the technical things. He said he won't be around because he's busy with something else within mind. But very late yesterday, he told us that he also did not have time to look at the input, so he did not respond to us, and we have to start at that time to put up something. So what we have put is not going to be as extensive as the Parliamentary Legal Services or as the IEC, but we will do such extensive things next week when we come. If we don't clear, I mean, if everything we need to clarify, we are not doing so today. So can it be flighted so that we start with the little that we have got and answering some of the questions that were raised here. Advocate Kumalo, who is flighting distance? Hello.
It is Mr. Njogo,
Yeah?
Honorable Minister, that is flighting. Mr. Njogo is flighting.
Yes, music. Yes. I can't see anything on my screen. I don't know what they're showing in other screens.
Yes, there's nothing on the screen yet, Honorable Minister. Muzi, you did flight it, but yeah, okay, it's back on the screen. Minister, can you see it?
Yes, but can you put slideshow, please? Some of us at our age, slideshow, you just please that thing that looks like a glass of wine. Why is your arrow running above it? Please put slideshow, Muzi. Just put an arrow on that thing, that last thing that looks like it.
Minister, let me assist. Muzi, if you go to the bottom right of the screen, next to the where you can increase the, just go to the left of it. Down.
The arrow is playing above it. I don't know why it's just keeping it. It's there. That thing that looks like a glass of wine, Muzi.
No,
on the far right.
Minister, it's Eddie. It's Eddie.
Oh, Eddie.
Eddie.
Yeah.
Okay.
No, I'm sorry.
Yes.
There's something on my screen that prevents me to put on the slideshow. So I'm sure you can't see it that side. Yeah.
Whatever it is.
Eddie, are you able to assist? Eddie? Okay,
yes,
there we go.
That's better. Yes, that's better. Okay, can you move to number 2? Yeah, because it's just an outline there, as you can see. Slide 3. Yes. And the purpose of the presentation, I'm sure, is just like the others, to respond to the public or oral public hearings. Next. Now, the responses we are doing today is specifically for the political party funding, because, Chair, we accept the what you call the criticisms or the concerns about some of the things that were left out, where we're supposed to be independent or independent representative or independent candidate. But we believe those are very technical. So we're dealing mostly with substantive issues here. And in doing so, we want to refer you to Section 236 of the Constitution of the Republic as a guiding principle. Section 236 says, to enhance multi-party democracy, national legislation must provide for the funding of political parties participating in national and provincial legislation on an equitable and proportional basis. That is the Constitution, and we should not deviate from it. Anything you do in enhancing multi-party democracy through funding, you have got to follow the Constitution. In pursuance of this Section 236 of the Constitution, Parliament then came up with the Political Party Funding Act, which created 2 sources of funding, namely public funding, which is from the fiscus, and private funding, Section 2 and 3, respectively. Now, the Political Party Funding Act imposes restrictions on private funding, and I'm sure all members of Parliament know the reason. The reason was not to stifle multi-party democracy. The reasoning at that time was that parties need to be funded by the fiscus, so that, number one, they are able to run their political affairs, but they do so without being influenced by people who have got a lot of money. It was not meant that parties must not get money or not funding altogether, because they won't be able to run their affairs. So where you impose restriction on private funding to avoid undue influence, then the fiscus must stand up and take that role. But unfortunately, as you know, that did not happen. After this bill was passed, the fiscus did not come to the party. I personally because I'm the one who, from Home Affairs, I mean to say, as Minister of Home Affairs, all the monies that go to IEC for this purpose go through the Department of Home Affairs. I asked the then minister, not the present one, about this clause, and he said there's nothing he can do because of the nature of the economy at that time, which leaves parties in the lurch as far as I'm concerned. Now, the issue of distribution of funds, the rationale for clause 29 emanates from this section 232 of the Constitution, hence the usage of the proportional and equitable principle. Those principles must not be left behind because they are already there in Schedule 2 of the Act. What is being replaced is the 2/3 and 1/3 split, excuse application of these constitutional principles and bring about unintended consequences. I am not sure, Chair, because when a formula was determined of distributing funds from the fiscus in terms of this section 236 of the Constitution, in the legislation, it said the money must be distributed in a formula of 90-10, 90 proportional and 10 equitable, where whether you have 100 members and another party has got one, you will get the same amount of money if it is equitable. But if it's proportional, you get money in terms of your size, in terms of the number of MPs we have got, which we believe our democracy has always been unlike that. Next. So we are of the considered view that the addition of independence, the usage of 2/3 and 1/3 will split will not amount to allocation being proportional, not even equitable. So it means we will have dumped section 236 of the Constitution. Remember, when this bill was made, there were no independents, and we reject, Chairperson, the insinuation that this is not a consequential amendment. Consequential amendments are there because there's a new kid on the block who's not represented in any of the acts. So if you have to accommodate that a new kid, you are then doing it consequentially. So these formulas were based on political parties. They were not based on the belief, on the fact that there could be one entity where there will only be one party. Even if political parties could get one person, nobody could anticipate that during election they will get one seat. Nobody can. You can't sit and say this party is going to get one seat and all that. So when you do allocation formula for political parties, you assume that they are all equal. And then the electoral will determine which one is bigger. But once you have got independent, you know that whatever happens at the end, if an independent gets into parliament, there will only be one seat. So the formula must consider that very seriously. Otherwise, we wouldn't have done our job. So we are of the view that the allocations should also therefore be 90-10% split. That's the only way that it could lead to proportionality. In fact, we have got a table here, which unfortunately I don't have on your screen. As we're doing some mathematics, we can present it to you last week, which put 3 scenarios on the table. The first scenario is the 90-10, which was originally in the Act. The second scenario is 6733, which was an amendment of the Act. I do not know for what reasons. The third scenario is to use percentages, because there are 400 MPs. If you move them into percentages, you divide by 100, it becomes, you divide 100 by 400 MPs. If you take percentages, it will give you 0.25%, meaning every seat will get 0.5% of that funding. If you compare those 3 scenarios, 0.5% is definitely proportional. You get then the amount of money proportional to the parties. If party A has got 160 seats, the proportion is 40% of parliament, and the amount of money is 40%, exactly proportional. But if you do it 610, then that party will have got 25.7% of the funding. If it's 90-10, then it's 36%, which is closer to 40. So 90-10 is closer to proportionality. 0.25% is exactly proportionality. 63-33, it distorts everything. In fact, if you give you that formula, you'll find that proportionally speaking, independents are going to get 4 times what a political party member will get per seat. And we don't think that is very fair. So we will provide all those mathematical formulas next week to you. Next. The department, in terms of clause 4D, it is important to know that the proportionality principle is already contained in section 34.5 of the Financial Management of Parliament Provincial Legislators Act 2009, and that the bill merely extends its application to independent representatives. For ease of reference, clause 42D stipulates as follows: each party represented in the assembly must be provided with financial and administrative assistance in proportion to its representation to enable it and its leader to perform their functions in parliament effectively, and each independent representative must be provided with financial and administrative assistance in proportion to their representation to enable them to perform their functions in parliament effectively. That's what it says. Next. Now, the issue of the limitation of other limits, upper limits of donation. The department also notes the submissions and concerns raised by stakeholders on the powers of the president in determining the upper limits, disclosure limits of donations, and the president's powers to make regulations. It is important to state that these provisions, honorable members, are not new. They've been there for the past 5 years. If you look at the Political Party Funding Act, what do we mean? In the Political Party Funding Act passed in 2018, it says that these limits, upper limits and lower limits, they were not constant or permanent. The president could change them in regulations. They were not put in the act. They were mediated through regulations. And the regulations were passed by the president, as you know. And then it said the president can change that if the situation allows, and it will always be, wherever you put number in an act, you are stuck. You know how the IEC have to come in 2021 in the electoral electoral commission's amendments to amend the number of seats in each legislature, which in the Electoral Act 73 determined that they must be done by the 31st of March, 1999. They even wrote the year. The reason that that mishap happened is because we were about to go for elections in 1999, and they were saying by the 31st of March, seats must have been allocated because I think the election was going to be somewhere in April or May. So they put the 31st of March. Instead of saying the last month before elections, every election year, they said March 1999. So we had to follow 1999 until the act was amended. So even here, if we put amounts in the act, when things happen, you then have to go and amend the act. So it was put in the regulations, and it said the president will exercise it with resolution from parliament, which means he was not given unfettered powers as it's been claimed. He had to get a resolution from parliament, means parliament must be convinced that the figures must be changed. Now, in the new proposal, we are more or less saying the same thing, except that we are saying the act must determine how the president does it. And because from our experience with the issue of signature percentages, Parliament doesn't usually agree with each other. The signature percentages started at 50%, There was an argument, we went down to 30. There was an argument, we went down to 20. There was an argument, we went down to 15, and then ended up in court. So there must be some mechanism that avoids that, because whenever you come to numbers, there will be as many proposals as there are number of people or as there are number of parties. So we're finding a mechanism. And in this mechanism, we are saying, in the past 5 years, there's never been an inclination or indication that this power given to the president with a resolution from parliament is being abused or showing conflict of interest. It never did. We are hearing for the first time that for the past 5 years, because nothing changed. Even now, the president doesn't have a blank check. We said he must do so after consultation with political parties. And the legal team in parliament said the issue of in consultation with and after consultation with is problematic because there will never be agreement. But I'm afraid they are not telling us exactly what we need to put. But we chose after consultation with political parties. Both the president and political parties are working under a prescribed environment. In other words, even the parties are not given a blank check to determine, number one, consideration of objective factors such the actual fiscal contribution to public party funding, inflation, and the actual cost of running a party and running elections as submitted by parties. I'm sorry, the first one, the A, is not a political resolution, is in consultation with, after consultation with. Now, we say both parliament and the president must be guided within confined rules. Rule number one, the initial objective of saying everything must be funded by the fiscus, and the fiscus is not doing so, but this is throwing a little bit. Just now we've just received the money from Treasury, which must be distributed to political parties. It's going to come to you via IEC, but it is far, far, far less than what parties need to run an election or just to run their parties. So for that reason, they will still depend on private funding, which must work within various parameters. So we said 3 things must guide parliament and the president. Number one, how much did the fiscus give? If the fiscus gave almost 100%, then there will be zero from private funding. If the fiscus has given 50%, then the private funding must more or less cater for that 50%. So that's number one. How much the fiscus give? Number two, what is the inflation rate at that particular point in time? And number three, and very importantly, can political parties submit more or less as they do to the IEC? And we know that they can't lie because the IEC will punish them. The amount of money they need to run a political party during a normal period, and the amount of money they need to run a political party during an election period. What is the average? What on average do political parties spend, so that we are not going to be very far from them when we make the upper or lower limits? Next. Next slide. So, Chairperson, before I come to this final recommendation that we recommend, the Parliamentary Legal Services raised several questions which need to be responded to. On page 8 of the, can I take you back to the parliamentary document? Can you leave ours on the screen? And let's go to the parliamentary document, because they've raised quite a number of things. Starting with page 8, definition of correction of donation, but I want to deal specifically with section 10. Yes, thank you. Please put it on slideshow because it's very important. The Parliamentary Legal Services says they agree with the issue on Section 10. This is Section 10 of the Political Party Funding Act, as it was passed in 2018. The original section says no member of a political party should receive funding from any source other than for political party funding activities. Firstly, when you look at it, we don't know what purpose it will have. But secondly, it is frankly criminalizing people without their knowledge, because we argued very strongly that it just say any member of a political party. All of you here are members of political parties. If tomorrow we have got a funeral and I feel like contributing, we do so in our culture, I don't know in other cultures, to contribute. Or if I attend a party and I feel like contributing something, then it means I'm criminalized as far as that Section 10 of Political Party Funding Act is concerned. And how do you police it? That I went into my village to appease the ancestors, and somebody donated a goat to me, and yet the act says it has to be for political purposes. So we removed it. We removed that Section 10 altogether. But after removing it, we were faced with the issue of the Zondo Commission, where we were instructed by Zondo that we must insert in the Political Party Funding Act a clause that will criminalize any individual or any party who makes a donation with the expectation of some reward later, who will say, I want the tender. Now, the trick about it, which I want the committee to debate, is also how do you police that? How do you know that this person has got a motive when he's contributing to any political party? The only ones which we think will not have a motive are those who contribute to the fund itself into the IEC, which then will be displayed to all parties. But many individuals prefer to donate to a particular party because it represents their cause or they represent their beliefs. So we put that because of Zondo rather than the original Section 10. If it was not Zondo, the Section 10, we're just going to remove it altogether. But we thought we must amend it as such. I think there is Section 14 where the Parliament says only independent and political parties are included in this section. Section 14 relates to the Commission's duty to monitor compliance by political parties with the Act. And they are saying the DH will advise on policy intention. We will look into it because it might just be an omission. We'll look into it. I'm not very sure exactly how we arrived here, but I think it was a simple omission because we have got, there's no reason that we must not include all independent candidates and independent representatives. Then Section 19, 3 and 4, they say they agree with Section 19, which stipulates offenses and penalties. The amendment then introduced Section 3, which provides that any person who makes a donation to influence a tender or license commits an offense, stipulating the fine. I've already answered this one, that it was in response to Zondo. Then we go to page 22. Page 22, Parliamentary Legal Services clearly stipulate that there will be a problem if there's no mechanism to avoid a stalemate of after or in consultation with. But I'm worried about what they are putting here as an alternative. On that page 20, No, I made a mistake. Can you go back to page 20, please? I did not capture it very well. Page 20, yes. where he talks about unfettered discretion of the president. The president, leader of a party in consulting with PC, which portfolio committee, which comprise members of political party, decide the level of disclosures, is a conflict of interest. We want to understand why they say so. And they quote my vote count and say it infringes upon the right to make informed political decisions, as political parties could reduce disclosures through their the president. I don't know how political parties can do that because they all account to the IEC. If they can still do that, then it means even the present moment of what you call procedure of accounting to the IEC, it means it's useless. What worries me a lot, they say it is similar to an employee determining conditions of their own salary. In all honesty, how does that work? Because, I mean, how do you do donations? How do you equate them to a salary? A salary is a right for selling your labor power, and it's controlled by labor laws, and labor laws are very clear about that. Here, there is no employer, there's no employee. It's political party sitting and deciding among themselves what is fair and what is ethical and what will protect multi-party democracy. I found that analogy, unfortunately, very unfortunate. Now, follows bullet 5, which also shocks me. I must state very clear. It suggests that determination be made by an independent political body or be deleted, which we don't agree with. Or amendment to add Minister of Finance to the consultative process. I don't think we'll be against that one because Minister of Finance is the one that is bringing the source of the funding. But I want to ask, what is an independent political body? Because the moment you add the word political, it has got particular political views. If you are talking about the structure of like the IEC is not an independent political body. It's an independent political structure set up by parliament, by people who have been elected. This independent political body that must determine the fate of all political parties in parliament. Who has appointed it? Whose power is it working? In other words, where did they get their original powers from to be able to regulate political parties? Because the IEC is regulating all of us, having derived their power from people who have been elected in parliament. And so when they make a ruling against you, you will not complain. So under what law are we going to establish that independent political body? I really wish Parliamentary Legal Services can respond to us because I'm completely lost about that proposal of something called an independent political body because I don't know such an entity, honestly. If we go to page 22, that's what I was explaining later. Let me just finalize it. That even in the present act before it was amended, the president was acting only with the resolution of National Assembly. He had no unfettered powers. So even now, we are saying the Assembly must be very involved. I will argue strongly, Chair, unless somebody indicate to me otherwise. This story that political parties cannot determine their fate because they've got a conflict. They are the ones who are running their everyday activities. How does somebody coming from outside just come and say, this is good for you, this is not good for you? Who is this somebody? Which political parties did not have power to appoint and all that? Because as I'm saying, if it's the IEC saying so, we all know that we're responsible for the act that put an IEC into operation. And we discuss with them every time. We discuss with them in political parties and committee meetings. We agree with them there. And when they act on something, we know that is with our agreement. Now, this party body that just appears from heaven and is giving power to control political parties. I'm very much worried about it, honestly. On page 23, yes. Bullet point number 3, funding of political parties is fundamental to promotion of multi-party democracy. It is in the Constitution, 236. It could be argued that to place this power in the hands of the president, who carries many heads, may affect the principle of democracy inside the Constitution, hence rendering that provision unconstitutional. I think we have already answered that. That is not the president. He works with parliament, with political parties. Page 25. I'm not sure why the Parliamentary Legal Services is questioning us for allegedly not bringing the bill in parity to Electoral Act and amend Section 27 CB. When the act that was taken to court was passed, there was Section 31B and there was Section 27 CB. As far as I'm concerned, the people who went to court did not quote Section 31B. They only quoted Section 27 CB. And the judges could not rule on 31B. They just could not rule on that one. And that's why people have gone to court again. And you are aware that the matter is in court. I don't know whether amending it was to jump in front of the Constitutional Court and make a change after which we don't know what the Constitutional Court will say. But the only reason that it appeared like this is not out of no fault of our own. It's because the people who were litigating did not recognize or neglected the fact that these provisions are in two different parts of the Act, Section 31B and 27CB. So they took only one to court, and the court said, much as we see the other, the court can only rule on what is in front of them. And since they've run and run to court, we also want to see the clarity from court, what they will do. And many of us have written explanatory affidavits. Both parliaments and the IEC and Home Affairs are not opposing this matter in the Constitutional Court. But we wrote explanatory affidavit because if you look at the judgment, it clearly says they want they want some form of input from the Department of Home Affairs specifically. They said we can't just stay away because they said in a previous Constitutional Court judgment, if an executive passes a particular act and that act is being challenged in the Constitutional Court, the executive can just not say we abide. They must guide the court in the form of explanatory memorandum, even if they are not challenging it.
Minister, Honorable
Yes.
Minister,
Yes.
could you just bear with me for a minute? I see the hand of the co-chair, Honorable Chabani. Maybe if I can give him a chance just to say something.
No, thanks, co-chair. I wanted to assist the meeting on two grounds so that we are properly structured. I noted that the minister has indicated that the detailed report of responses or comments, they will still have to consolidate and submit to the portfolio committee on Monday. I get the sense that in his opening or in the body office input, he has indicated that. And secondly, I got a sense from the commission that the other matters that have been raised by the Parliamentary Legal Services, if I capture the Commissioner matter, that they still have to come back to the committee. I'll suggest, Chair, that if the minister has raised those two, except that of the commission, which I think there's clarity on the process, we may propose that the minister may not deal with the responses. I think he has already entered into the responses. We await the final document from him and the legal team, which will more assist the committee. And if you note that in the submission, in the response of the Parliamentary Legal Services, some of the issues that are raised there are submissions that arise on the oral responses, are not opinion that is or responses from legal services. So I just want to raise those two issues, Chair. And I think the minister will understand that the approach we seek to take. Chair will assist me. Thank you.
Thank you, Honorable Chabani, for those comments and perhaps calling the process to order. Minister, I think you understand what was commented on by my co-chair, Honorable Chabani. I think in terms of what you indicated, that the department will provide the two committees with a more detailed response in terms of all the public comments that were received on the bill, given that you had some challenges in the department, especially with legal support. So perhaps, Minister, if you indulge us, we leave the matter at that, but we suggest that you provide us with the detailed responses also in due time, so that on Monday, when the department does take the committee through, or the joint committees through, then we'd be able to then have a much more constructive engagement in terms of the department's presentation. But also, as the chair had said, that the outstanding issues that the IEC would also want to liaise with the legal team of Parliament, that we should allow for that process as well to unfold. Minister, on your side, I hope you're okay that we cut your presentation for now till we get the more detailed submission from the department. Minister?
Yeah, absolutely, Chair. I really understand and I accept it. Part of my confusion was that the parliamentary legal services were not just responding to the issues raised by the members of the public. They were throwing it over to Home Affairs. And I thought maybe I'm required to respond now. Yes, because they were throwing lots of things and say Home Affairs must explain this, must explain that. So I do understand, I accept very fully, and next week we will come with a full clause by clause, what you call inputs. Thank you very much, Chair. I appreciate that very much.
No, thank you very much, Minister. And then I think those areas where legal requires policy clarification from the department, then you can also perhaps provide those aspects. I think you have tried to cover some of it today, but perhaps on Monday you could come with a more comprehensive kind of approach to those issues. Thank you, Minister. Thank you very much. And I think we should thank all four presentations that we've received today. And perhaps we should note, honourable members, perhaps we should note all four presentations. Obviously, we would expect the detailed presentation from the Department of Home Affairs, as well as those other areas that the IEC would want to liaise with legal on, and get that clarity as well in our next meeting on Monday. Let me then hand over to Honourable Chabani, perhaps then to take the meeting forward and or close the meeting. Honourable Chabani.
Thank you very much, Co-Chair. Well, I think she has already appreciated all the responses from the Parliamentary Legal Services, the IEC, Department of Communication, and Department of Home Affairs. We'll note the 4 presentations, and we'll come back to deliberate. I want to establish for members if there are questions in terms of the process, so that we don't move without a proper guidance from members. Okay, anyone can raise the hand, then we go to item number MOD. For adoption, that we must proceed with the bill. Can I check if there are questions on the 4 presentation or on the process, which I think will assist the members?
Chair,
Yes.
I'm sorry, I'm unable to raise my hand.
Yeah.
You want to now go to the process of the motion of desirability. However, I need to be guided on that, because currently with some of the clauses in the bill pertaining to party funding and the powers of the president, which I view as substantive and not consequential in nature, we would not deem the bill desirable. So I would like to know whether you won't want to defer this to Monday, or what the process is in this regard. Because I think without us, because currently as the bill stands, in my view, there are some substantive changes that is being made and is not consequential in nature. And that would, in my view, deem the bill not desirable. So I thought maybe that would have come then after we would have had the deliberations on Monday. But I might be wrong. I'm just trying to be guided. Thank you.
Okay, noted. I see the end of Honorable Modise Mtsa.
Thank you very much, Chair. My comment would be on the process, and I would also want to support Honorable Lizelle with regard to you wanting to ask for desirability. I think, Chair, as you would have outlined the process, that we will have deliberations, because we need to go back and read the presentations and assess. And therefore, in the next scheduled meeting, which will be on a Tuesday or Monday, we will then deliberate on that. And I think it's there then where we will then speak to the issues of adopting the bill for desirability or not. So thank you very much, Chair. I support that. Thank you.
Thank you very much. Those are the proposal that would defer the item to Monday after we've deliberated, but also received more responses from the IEC and the Department of Home Affairs. I don't think that is a contrary view to that. We can carry that. Mr. Matonzi and Daksha.
Sorry,
can I
Chair, there is the end of Mr. Stephen Swart, Honorable Stephen Swart.
Sorry, Honorable Stephen Swart.
Yes, thank you. Thank you, co-chairs. I just wanted clarity because obviously we've had the presentations, we're still waiting for documentation, and I presume there will be time to ask questions of clarity as well from the presenters once we've got the final documents, because there are a number of questions that I don't want to belabor now this afternoon, but that I wanted to ask. But I trust that there will be an opportunity for that as well once it's part of deliberations and asking questions of clarity. But I am in support of the process so far. Thank you, Chair.
Thanks, Honorable Swart, for that, and also welcome to the Joint Select Committee. Mr. Matonzi, is there any other matter now that you have turned off all the items?
Chairperson, the other matter, I think we'll still have to work on the revised program, since we are not having a meeting tomorrow and Sunday. So we are meeting at 9 o'clock on Monday until 1 o'clock, but we can extend that if we needs be. But there's no other issue that needs to to be done today. What also I will need as a clarity, Chairperson, it means on Monday when we meet, all the stakeholders that presented today, they should be here, and also the select committee should be here as well.
No, I think that is clear, Mr. Matonsi. We'll reconvene on Monday. What will happen is that we'll meet with the content advisor and the two, and Mr. Daksha and the select committee chair to revise the program and present the proposed revised program on Monday for the joint committee to adopt, so that it's easier for us to proceed with the time, noting that it's going to be a hectic week, SONA debates, and so I think we need to rework our time so that we're able to conclude this process. Commissioner Miepta, we're clear that on Monday you'll come back to the committee. Minister, you'll come back to the committee. And if there are any documents, Minister, as you've indicated, please, if we can get those documents at least by tomorrow evening, so that members have a day or so to interact with those responses or detailed response. Co-chair, I think there's no any other matter. We can stand off the meeting. Then, Commissioner Mebza?
Excuse my interruption. We were scheduled on Monday to present the work that we had done for registration weekend. I imagine that given the urgency of this, we will not be required to do the presentation on the registration weekend outcomes. Will you direct us on that matter?
Yeah, I think we'll have to revise our program. We'll indicate to you, but of our interest is this subject matter we're dealing with. We'll consult with the select chair, and we'll see how we will reschedule within February. Is that clear?
Appreciated. We will hear from you.
Thank you, Commissioner Mutsa. Colleagues, honorable
Chairperson.
Minister.
Yes, since we have just finished in Cape Town, as you know, because of this portfolio committee will remain here, we are still going to travel and come together. Is there a possibility that you can allow us to present, to hand over the document on Sunday morning rather than tomorrow? Because we still have to work on it. I told you, we were only told yesterday that our legal counsel is not able to do anything for us.
Thank you, Minister. We're granting you that Sunday in the morning, 9 o'clock.
Okay. Thank you. Thank you.
Thank you. Thanks, honorable members. Thank you, colleagues. The meeting stands adjourned.
Thank you. Thank you, Chair. Thank you,
Thank you.
member.
Thank you.